Hello to everybody. My name is Matjaž Kovač. I am lawyer at Ministry of Infrastructure, Republic of Slovenia, and I working in public procurement section. Also, I am a PhD student at Faculty of Law, University of Maribor. I would like to represent my presentation at International Conference of Research in Business Management and Economics. But I have to apologize about the missing presentation at Saturday afternoon. I had some problems with internet connections. So my presentation is about analysis of taxation of income related to the permanent establishment according to the OECD model. Well, foreign enterprises in case of performing business activity and about taxation of income should consider two or more legal system, or else the legal system of the country in which the enterprise have permanent establishment, and the legal system of the country in which the resident is enterprise or permanent establishment. For most of the formal income, especially income from business activity and income from investment activity, the problem of double taxation is solved through model conventions of OECD for the avoidance of double taxation with respect to taxes on income and capital. The concept of permanent establishment in its substance binds to the notion of double taxation and the elimination of double taxation. National legislation of the OECD country differently regulates the taxation of gains tied to the permanent establishment. The development of world trade, transparent treatment of the OECD model concerning the abolition of double taxation and e-commerce have resulted to determine the general and specific rules concerning which profits belong to the permanent establishment and how and where it could become taxable, such a profit. Well, permanent establishment is a place of business in which the business of a particular part of a multinational company is wholly or partly carried on. The generally recognized principle of taxation, the business profits of multinational companies, is that taxation of the profit of a resident company in a non-resident country is not permitted, unless the resident company operates in a non-resident country through the permanent establishment there. Double taxation treaties provide that profits are taxed in the country in which the resident company is situated, unless it has a permanent establishment in other contracting states. If the company has a permanent establishment in other contracting states, the profits in respect to the permanent establishment shall be taxable in the country of operation of that permanent establishment. The general criteria for determining the level of the profit of a permanent establishment and determined in such a way that the permanent establishment adds to the profit that the permanent establishment would gain from operating as a fully independent company. Another case and another way of determining the profit of a permanent establishment, however, relates to cases where the company operates if it is used to the keys to distribute the profit of the wholly company among these components. In this case, these keys are used to determine the permanent establishment profits. Now we will talk about the profit of the entire company. The first paragraph of Article 7 of the OECD model reads as follows. The profit of an enterprise of a contracting state shall be taxable only in that state unless the enterprise carries on business in the other contracting states through the permanent establishment, or PE. The profits of the business may be taxed in another country, but to the extent that can be attributed to this PE. The definition of company-wide profit refers to the restriction of taxation rights in a permanent establishment country. In theory, two directions have emerged: the development of defining the profit of a company, which is related to the operations of PE. First directions is determination of taxable profits of the PE through relevant business activities. And another direction is the determination of the taxable profit of the PE through the functional division of the company. Relevant business activities in a non-resident country resulting from the emerge of the PE and also indirectly taxable profit relate to the business activities in which the PE plays a significant role. The rule should be taken that the profits from the relevant business activities of the PE must not exceed the profits made by the whole company in the area concerned. The profit of the entire company is that obtained by the company through business activities through third parties, as well as through business activities through controlled transactions with related parties. Among the countries that have adopted this method, there are many differences in how to adopt relevant business activities in practice. The breadth of precision of the definition of relevant business activities has a major impact on the fact that the above-mentioned operating system will have any practical implications. It is also important to determine the period of consideration of relevant business activities. In the event that business activities results in 1 year loss, we will not be able to cover them through the profit associated with the PE activities for that period if we have determined the relevant business activity for a longer period of time. Some countries consider relevant business activities in their gross income, while some links these activities separately from income and separately from the cost of the company. Now, the second approach to resolving the taxable profit of the PE is aimed at the functional division of business activities of the company into several units. This approach does not limit the profits that are tied to the permanent establishment in relation to the relationships with the profits of the whole company. Functional division of business activities takes into account the profits associated with the PE, although they have not been realized through the company. On the other hand, the relevant business activities are not linked to the profits of the PE unless they have been realized with the company through transactions with other business entities. Simplifying the cooperation between the two principles of determining the profit of the whole company, we find that business entities with different approaches to solving the problem in question can differently solve the problem of double taxation activities. Double taxation will be strongest when one entity adheres to the principle of functional profit sharing and the other to profit based on relevant business activities. Now we have the second paragraph of Article 7, and this second paragraph of Article 7 is related to profits of the operation of the PE. This second paragraph follows: if an enterprise of a contracting state conducts business in the other contracting state through the permanent establishment in each of the contracting states, such profits shall be attributed to the other permanent establishment or PE. This will be expected to have been generated if it had been an independent and separate undertaking engaged in equal treatment or similar activities under the same or similar conditions and would operate completely independently on the company on which the PE is. The OECD model concerns the PE as a separate entity carrying out similar activities or similar terms and considers profits by applying the rule of comparable market price. The aim of the OECD model approach is not to achieve equal profit between PE and affiliates or parent companies, but to set rules between different parts of a single entity on the basis of the transfer pricing arising from relevant party transactions. So the actual and the functional analysis of the OECD model is based on the deception of the PE as a formation that differs from the rest of the company, especially in terms of different and separate functions and different and separate operating conditions. It is especially important to take into account the risk functions of the company that related to the distributions of assets and risk. The actual and functional analysis investigates all the facts and circumstances in which the assets of the company were used for the function and operation of the PE and the condition under which the assets were used. In doing so, it also takes into account the factors that determine which part of the entire enterprise have been trained and designed as a carrier of economic activity and the property of this economic activity. In view of the aforementioned provisions of the second paragraph of Article 7, two stages of determining the profit associated with the operations of the PE have been established. The first stage is defining the activities and conditions for the demarcation between the PE and other parts of the company. And the second stage is determination of profits to distinguish between PE and the other parts of the company on the basis of benchmarkings. For a comparative analysis of the activities and the conditions of the demarcation between the PE and the company, it is necessary to define the relevant economic activities and characteristics that influence the determination of activities and conditions. It is necessary to compare the characteristic of transactions or business activities that have an impact on the functioning of conditions in a system of comparable market price. When we are analyzing the functions of a permanent establishment, we must pay particular attention to the consideration of usable assets and the foreseeable business danger. In doing so, we must take into account the actual analysis of all relevant economic activities and characteristics and conditions relating to the operation of the permanent establishment. Functional analysis must also take into account the assets used as well as the operations through the branches. The determination of the assets used and the protection of the PE activities is difficult to determine, especially when these elements fall within the business of the entire company. Now we are going to the third paragraph of the Article 7 of OECD model. And this paragraph tells us about costs related to the operation of the PE. The deduction of costs incurred for the purpose of the PE, including the management and general administrative costs incurred either in the country in which the PE is located or elsewhere, shall be allowed in determining the profits of the permanent establishment. We have several theories have emerged regarding the costs associated with the operations of the PE. But most important are two theories. In the first place, the OECD cost provisions are primarily set up to cover the costs of the PE, which should not be made on incorrect assumptions, mainly because the costs are out of the reach of the PE or are not directly related to the operations of the PE. The second theory relates to the system of comparative market prices and have two orientations. First orientation is that the costs incurred by the PE must be deducted, although they have higher than the comparative market price system. And the other orientation is that the other parts of the company cannot cover more costs than those related to the costs incurred in the operations of the PE, unless the costs are related to the operation of a third party. The basic purpose of the provisions is to ensure that the relevant costs are deducted in relation to the PE income without contracting the system of comparable market price. The fourth paragraph of Article 7 of OECD models read as follows. It was customary in a contracting state to determine the profits attributed to the PE on the basis of the distribution of the total profits of the enterprise into different portions. It cannot prevent that contracting state from determining the profits to be taxed by such distribution as a customary. The method of distribution must be in line with the principles of world taxation. The above rule can only be respected if the total profit of the distributed things can be distinguished from the individual transaction by the basic characteristic of the transaction and taxation of the PE business. This conception of taxing the business of PE is very unknown unless PE is the holder of all activities related to the whole company, so that the rest of the company operates in only one business activity. In some countries, it is common for profits to be attributed to the PE to be determined not on the basis of separate accounting or profit estimations, taking into account the principle of comparability of the market prices, but by dividing the profits of the enterprise as a whole into some parts. And now we have at last the specific ways of dealing with PE profits. This is paragraph 5, 6, and 7, article 7 of the OECD model. And these paragraphs are that about PE, that PE is not credited from the profits because it only purchases goods and merchandise for the company as a whole. And the profit attributable to the PE shall be determined by the same method year after year, unless there is a good and sufficient reason to the contrary. And the article 7, paragraph 7, last paragraph of this article is that if profit includes parts of the income that are dealt with separately, only such income to this part of income can be treated separately in a way of taxation. So now we are coming to the conclusion of my presentation and my article. What is the conclusion? As regards of the taxation of non-residents, it is of the utmost importance to consider the criteria of eliminating double taxation. The taxation system of world income, due to the specific characteristic of world income, almost always causes the appearance of double taxation. The theory and practice have formulated two basic criteria for eliminating double taxation. The first criteria is linked to the source of income and has its confirmation in the fact that the tax is directly linked to the income, which is organically linked to the area where it was obtained. The second criterion of the double taxation concerns the notions of resident and residence as a whole. As regards the taxation of non-residents, the rule of the method of deduction of tax paid abroad was adopted, which is in accordance with the accepted method of unlimited tax liability. So in some countries, it is common for profits to be attributed to the permanent establishments to be determined not on the basis of separate accounting and profit estimation, taking into account the principle of comparability of market price, but by dividing these profits of the enterprise as a whole into parts which belong to permanent establishment. So this is my presentation about my article about taxation of permanent establishment. Because these problems with my presentation on Saturday, I would like to stress that you can send me some questions via email. Here is my email, here's my general presentation of my firm. And so we can communicate. I will be very pleased to answer your question about the taxation, international taxation, permanent establishment taxation, and also about my specialty, common consolidated tax base. Thank you for your attention and see you soon. Thank you.